They're very adamant that they don't want their kids to become the late, great Christian Brando. How many of you remember who Christian Brando was? Okay, Marlon Brando's kid, big trust baby, didn't do anything with his life and finally died of a drug overdose. Okay? Most people don't want that for their kids, so they put in provision that says, if you want your money at 25, I want a degree. No degree, no money. You can still get it when you get older, but that's it. You can do variations on that too, but that's the stuff that's the people like for custom stuff. Now, next, as a result of your planning, you're going to decide who you want to fulfill the various job responsibilities. Probably the most important one is guardians of the kids. Who's going to take care of them? Healthcare agents, who's going to make healthcare decisions for you if you can't make them for yourself? Financial agents, who's going to manage your finances if you're incapacitated? Who's going to run your trust when you're gone? If we got to go to probate court, who's going to be executor of your will? And if we need to do a conservatorship, which I'll explain shortly, who's going to be your conservator? Now, I'm going to go through all these as we go through the documents, so don't feel like, hey, you're telling me all this stuff, but it doesn't make sense. It will. Okay? The basic point about this is you have several different jobs to fulfill. The one person might not be the right person for all of those. For example, in my family, my sister's a registered nurse. She makes the healthcare decisions for mom if mom can't do them. I'm the financial person, so I run the trust. Okay? Now, another thing I want to point out is that, as I'm going to show you, trusts are private. There's no court supervision, which is what you want. You're trying to keep the government out of your business. So, a lot of times people say, well, I want my sister to be guardian of the kids and I want her to be trustee of the trust. The problem with that is you have the same person taking care of the kids that's guardian, that's watching the money. You don't have any system of check and balances there. She could just as easily use that money for her kids as she could for yours. No disrespect to anybody's sister, but as we all have come to know, money changes people. And big money changes people big time. Okay? So I'm an advocate of having the person that takes care of the kids be different from the person who runs the money. Okay? That way you have the person who's taking care of the money, watch what's going on with the kids, and you have the person who's watching the kids, watching what the trustee is doing with the money. It's really a good thing to do. I'm very conservative in that respect. Some people have overridden that and said, no, I want my sister to do it. And I'm like, fine. As long as you're informed about what the risks are and you want to go forward with it, I'm fine with that. Okay? Integration with financial planning, tax planning, and asset structure. This has to do with retirement accounts, 401ks, IRAs, annuities, all of those things. They're what I call problem children in estate planning. And the reason is that while you're contributing to these assets, the IRS is not getting paid. And as we all know, the IRS always gets paid. So you got to be careful when you're dealing with your 401ks. I'll talk about that a little bit more later in the seminar. Liquidity for survivors. This has to do with life insurance. You can have the greatest set of documents in the world, but if you don't have the money to take care of your family if something happens to you, the documents are worthless. My dad had a bunch of life insurance. That's why I'm here. Okay? That's also why I'm in insurance business, because I was watching what other people were doing to my clients and I didn't like it. So I got my license. Okay? So, in any event, I don't care whether you get the cheapest term insurance out there. Just get it. Okay? Because I have seen things, people say, oh, nothing's going to happen to me, I'm in perfect health. Yeah, you were in perfect health until you came driving down from Verona and some drunk killed you. Okay? You ever notice it's really nice people that get killed by the drunk drivers? Okay? So the bottom line is make sure you take care of yourself, okay, and your family. Okay. Good planning helps to avoid conflicts, delays, and expenses. The big ones are going to be probate court costs and attorney fees. Why bother? Well, good news, if you plan in advance, you get to take action and reap the rewards. Bad news, if you don't plan in advance, you have to react and suffer the consequences. I get phone calls like this on a yearly basis. So-and-so died. We don't have any money to pay the gas and the electric bill. We don't know what we're going to do. We don't know what we're going to do. We don't know what we're going to do. And they expect me to have like all the magic answers, and I don't. Okay? On the other side, 4 years ago, I lost one of my best friends. And she is a wonderful lady, And she had 4 kids from her first marriage and a second husband, and the kids and the second husband didn't really get along all that well. Okay? She died at age 51 from colon cancer. She had all her ducks in a row. I mean, that thing was locked up tight. We did everything at her dining room table. Her sister was the successor trustee. We dealt with the ex-husband. The kids were all taken care of, and the kids, 3 of the kids now are over 24 years old. They all own a house up in Temecula. The youngest one is just finishing up college and is looking forward to buying his house too as soon as he gets a job. Okay? The second husband went back to Arkansas, and he's sitting on his house at his lake, fishing every day, doing whatever he wants. There was no government involvement, there was no arguing, there was no fighting, there was no litigation, there was no nothing. Everything just went nice and smooth. That's the benefit of doing what you're doing now. You're not going to know, but your family will. Okay? So now let's talk about the California probate system. It's state, not federal, state specific. Every state has their own set of probate rules. So what goes on in New York, New Jersey, or Nevada, I have no idea. I'm licensed to practice in the state of California. Okay? So if you move there, I have no idea what to tell you about what's going to happen. You'll have to consult an attorney there. What I can tell you is from what I've seen, California documents travel really well. Or at least mine do, from everything I've seen. Okay? Now, because you live in California and you are a resident of the state of California, you are subject to the division of the Superior Court of the state of California. Okay? Now, if you get in a dispute with somebody, you go to the civil division. Car accident, real estate dispute, employment dispute. Divorce or custody, go to the family division. People that get arrested go to the criminal division. And then the division that we're going to talk about is the probate division. Everybody always wants to know, what is probate? It's a courtroom. What is the purpose of the probate court? It is to protect legally incompetent parties. Deceased, disabled, incapacitated. So if your loved one or you or one of those three, you or your family goes and sees the probate judge. Now, first thing everybody wants to know, if my spouse died, do I got to go to probate? The answer is no. If you're married and you're asked to either community property, which is all property acquired during marriage, or held in the form of ownership called husband and wife as joint tenants, there's no probate at the death of the first spouse. That obviously begs the question, well, why is probate necessary in the first place? And the answer to that question, excuse me, has to do with a concept that I've termed signature authority. I've never heard anybody define any more clearly than that, so I just picked signature authority. If you think about it, there's 2 ways that you could voluntarily transfer property from you to somebody else. You could either hand it over, like I'm handing this woman the clicker, or you sign it over, right? Now everybody says, wait a minute, what about point and click on the internet? That's an electronic signature, isn't it? You're checking the little box that says, I have agreed, and blah, 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 blah. Okay? So when you sign your name, what exactly are you doing? You're voluntarily transferring something from you to somebody else. You're either transferring money in return for goods and services, like at the grocery store or the electronics store or whatever, or you're transferring services in return for money, like here at work. You probably sign an employment agreement somewhere along the line. So you give services, they give you money. The way that all happened is you sign your name somewhere. Whether it was a check, credit card, slip, purchase and sale agreement, whatever. What you did when you signed was, I hereby voluntarily transfer this in return for that. Because look at this check. Everything looks great. But if there's no signature there, is that check worth anything? No. That's what binds you, your signature. So always keep that in mind. That's why everybody says it's not a done deal unless sign on the dotted line. Okay? So that's voluntary transfer. Let's talk about involuntary transfer. Who in the state can substitute their signature for yours and transfer your assets without your consent? The only one who can do that is a Superior Court judge via his or her signature on a court order. I'm sorry, Mrs. Pai, what's your first name?
Martine.
Martine. So Martine's driving down the road, runs over little Mr. on Mr. Motorcycle. Mr. Motorcycle gets upset, gets hurt, goes to the doctor, then sees the personal injury lawyer. Personal injury lawyer sues Martine. Judge says, Martine, it's your fault. Pay Mr. Motorcycle $10,000. Well, what does Martine say? She says, it was not my fault. I'm not paying him a dime. Can you do that?
Sure.
Okay. So what can little Mr. Motorcycle do? Well, he can get a court order signed by the judge to either garnish her wages or levy her bank account. What a court order is a piece of paper signed by a judge. That piece of paper signed by the judge shows up at payroll here, and what do? They take the money out of her paycheck and give it to Mr. Motorcycle. Okay? So in effect, what happened? The judge's signature was substituted for hers to move the money to little Mr. Motorcycle. Excuse me. So we know if the way you voluntarily transfer property is by signing something, and we know the only way property can be taken away from you involuntarily is via a signature on a court order. I have a question for you. Have you ever seen anybody in a coma and a casket sign their name? Probably not. Good morning, Your Honor. Welcome to the probate court. I don't care what anybody tells you. Probate is nothing more than a really cumbersome and overly legislated asset transfer procedure. The bottom line is you can't sign for yourself, and the only one who can substitute for you is the judge. That's why back when we talked about community property and joint tenancy, there was no probate at the death of the first spouse. Why? Because when you're talking about community property and joint tenancy, how many signers are we talking about? Something happens to one, survivor can still sign. But now we have a single person. They're either unmarried, divorced, or widowed, and they can't sign. Now we need the judge. Okay? So everything I'm going to talk about from here on out is talking about putting documents and legal entities in place so you or your family doesn't have to go see the judge. So, first thing, let's talk about incapacity and disability. If you become incapacitated, we have to go to court and get a conservatorship appointed over you. Conservator of your person means who takes care of you physically, what doctors you go to, where you live, what clothes you wear, etc. Conservator of your estate is who manages your money. You can have two separate people, one for the conservator for the person and one for the conservator for the estate, or you can have one person do both jobs. It's a matter of personal choice. Problem with conservatorships, they are expensive, okay? And court filing fees and investigative fees, right at the beginning, you're talking $1,500. Forget, not even include talking attorney fees, okay? You're in the system, okay? That means the wheels of justice turn slowly. In this county, we used to have 4 probate courts, then it went down to 3. Then because of the budget cuts, they just closed the North County Court, probate court, and we're down to 2 judges that are doing the job that 4 judges used to do. So if you think court gets delayed before you were dealing with this, it's even worse now, okay? And it's emotionally traumatic. You're basically traipsing mom into court telling the judge, mom's incompetent. Mom's not going to like hearing that. I don't know if any of you have ever had any experience with people suffering from Alzheimer's and dementia, but one of the first warning signs is anger. And you start talking about taking away their freedom and doing things for them, and look out. You start putting a conservatorship in the middle of this, it is not a fun place to be. I don't know any kids that are conservators of their parents that enjoy it. Okay? It's just not a good place to be. So the way to stay out of this is to do the 2 documents I talked about at the beginning. And if you look here on the right inside the handout, they're right there. Okay? And by the way, the handouts I think are the important handouts for you to take away that will hopefully jog your memory when you leave. Okay? All right. Now, first document is called the Durable Power of Attorney for Financial Management, otherwise known as a DPA. Okay? What is a power of attorney? Power of attorney says, I give Martine the right to sign my name. That's what a power of attorney means. Okay? Now, first thing you want to know about a power of attorney is, when I die, it dies with me. You cannot have power of attorney for a dead person because they have nothing to give you at that point in time. I hear it all the time, Joe died, but I got power of attorney. No. When Joe dies, we look to his will and his trust to see what to do. But while you're alive, powers of attorney are very useful. Okay? Now, there's that magic word up at the front, durable. Because a regular power of attorney, in order to be effective, has to have 2 things. Number 1, when I do it, I'm competent and I'm alive. But if I become incompetent, you can't even do a durable power of attorney. You can only do a power of attorney when you're competent. Okay? So that's why you want to do them in advance of mom getting sick. Okay? So the first thing is that I have to be competent and I have to be alive. Okay? But if you have a durable power of attorney, the only thing that matters is that when I did the power of attorney, I was competent. If I gave Martine durable power of attorney,